everyone ready? Court rise.
Mr. Watson, QC.
My lord. Could I start then with ground one, test of justification? The respondent's position can be summarised as follows. Firstly, given the substantial margin of judgment which ought properly to be afforded in this context, whether approached on the basis of a conventional proportionality test, as that test applies here, or whether approached on the basis, as the lower court expressed its conclusion, of a manifestly disproportionate test, doesn't make any material difference. The analogy here is with Lord Justice Singh's finding in Drexler at paragraph 52. Secondly, the underlying point is that this
Hang on
is
a second.
Sorry. See Drexler, Singh, paragraph 52. Authorities, tab 15.
Thank you.
The underlying point is that this is not a binary question, as the Divisional Court identified. There is a substantial margin of judgment which applies given A, the nature of the status relied upon, and the subject matter, etc. And 3, there are certainly no grounds on the authorities here materially to reduce the margin of judgment identified by the lower court.
This is not a binary question because, sorry?
This is as a matter of principle. The question of the margin of judgment afforded to the court is not a binary question, i.e. slim margin or fully extensive margin, but it's a fact-sensitive assessment made in the context of any particular case before the courts. And on any view, the test of justification is met here, given firstly that substantial margin, but also because of the powerful objective justification for Rule 7.1a identified by the Divisional Court and for the reasons it gave, and at some length. If, therefore, this court were to conclude that the Divisional Court applied the wrong test, the outcome would be the same. My Lords, can I then just start very briefly with the Divisional Court decision, because I do want to point out that there are various features of it that suggest that it didn't intend, in fact, to apply a manifestly without reasonable foundation test at all. That wasn't the basis upon which the issue was approached before it, and it didn't make any particular findings in that regard. And the way that my learned friend gets there, obviously, is to read the conclusion at paragraph 120, alongside Lord Justice Leggett's equiparation of that test with the manifestly without reasonable foundation test in SC at paragraph 89. But it isn't, in fact, a feature of the Divisional Court's test. And suggesting that the Divisional Court did not apply it in that way are the following points. Firstly, as I've mentioned already, paragraph 98, not a binary question. Depending on the nature of the ground on which the difference in treatment is based, and on other factors such as the objective of the measure. 2, the discussion of the status question and the rationale for finding objective justification didn't suggest either that a manifestly without reasonable foundation test was being applied. 3, your Lordships and my Lady will have seen the application for the response for permission, for tab 13, page 135, referring again to the issue of proportionality requiring a, quote, quintessentially fact-sensitive assessment, and its finding of a substantial margin of judgment. And its observation that its conclusion was only that, on the facts here, the measure fell within that generous margin. And then finally, my Lady, my Lords, we have the subsequent decision of Lord Justice Hickinbottom in JCWI, Authorities tab 16, which of course looked directly at the question as to when the manifestly without reasonable foundation test should apply. And there, Lord Justice Hickinbottom identified at paragraph 132, little Roman 2, that the court had not been referred to any case in domestic law where that criteria, manifestly without reasonable foundation, has been considered, let alone applied, in the context of a legislative or executive measure other than in the field of welfare benefits, which obviously wouldn't have been the case if, in fact, that test had deliberately been applied here. And, of course, Akbar was clearly in mind because it was rehearsed at paragraph 136.
So what do we gain from that last point on Justice Higginbottom's decision?
The run of all those points, my lords, is to the effect that it isn't at all clear that the manifestly without reasonable foundation test was in fact applied. In fact, the indications are that rather the court considered it was a fact-sensitive assessment, that here a substantial and generous margin of appreciation should be afforded to the respondent in the decisions and in the court's review of the rule. And my lords, in those circumstances, that is strong support for the proposition that there is here a distinction without a la Drexler, paragraph 52, when you're either going under conventional proportionality or applying a manifestly without reasonable foundation test. My lords, turning then to the substantial margin, the first point I note on behalf of the respondent is that the appellant takes as his starting point that there are two considerations: subject matter and rights affected. My lords, there is, my lady, there is on the authorities an anterior question, namely what is the nature of the status relied on under Article 14. And that, in my submission, is the proper place to start here. And I do need to ask the court just to turn please to bar, the decision in bar, ECHR in bar, in the authorities, tab 19. This is to address the point that we may be in a situation where we're dealing with all other status, but in circumstances where in fact it's all in the context of nationality, and that should somehow play in to the court's approach. So my lords, just bar tab 19, starting at paragraph 37 for these purposes. Reference there to, I think is considered the orthodoxy, that subject matter and background will affect the scope of the margin, paragraph 37. Wide margin is usually allowed under convention when it comes to general measures of economic and social strategy.
So where are you reading from?
Paragraph 37.
Thank you.
And against that background, which is then further rehearsed that I don't need to take the court to, paragraph 44. The court must therefore decide, based on the facts of bar obviously, whether the ground of distinction was indeed the applicant's son's immigration status, or rather his nationality, because that, as we'll see, will affect the approach to the margin. And in that sense, this was a binary judgment, if you like. It's immigration or nationality. So we see that over the page. The finding is at the end of paragraph 44. The restriction, this was on the restriction of access to funds, which led to the reduction, I think, in housing benefit. The applicant's son was granted entry on the express condition he would not have recourse to public funds. The court finds this was a conditional legal status, not the fact that he was Sierra Leonean national origin, and that resulted in the differential treatment. Now then the finding that immigration status can amount to other status for the purposes of Article 14. Leaving that aside for one moment, paragraph 46. The court finds, therefore, in line with previous conclusions, that the fact immigration status is a status conferred by law, rather than one inherent, doesn't preclude it from amounting to other status. But then, 47, this is the critical part in my submission, The nature of the status upon which differential treatment is based weighs heavily in determining the scope of the margin of appreciation to be afforded. And then recites the particular aspects of immigration status, not inherent or immutable, etc. And therefore, bottom line, justification required will not be as weighty as in the case of a distinction based, for example, on nationality. Furthermore, given the subject matter of this case, provision of housing to those in need, predominantly socio-economic in nature, margin of appreciation will be relatively wide. So, my lords, that is, as I've described it, the binary decision as to status, cited by the Divisional Court at paragraph 82. And then, briefly, if I may, just ask the Court to turn, please, to Lord Justice Leggett's decision in SC, Authorities 14, paragraph 66. Because there's a reference to paragraph 66 behind flag 14.
Can you give us those references again, please?
So sorry, tab 14.
Tab 14.
Paragraph 66.
Thank you.
Lord Justice Leggett in C or SC. For this proposition, this is citing Lord Walker's concentric circles, concluding with the corollary. This is at the end of the paragraph, 66. The corollary of this scheme is that the more peripheral or debatable any suggested personal characteristics, they're less likely to come within the most sensitive area where discrimination is particularly difficult to justify. And again, my lords, that, my lady, that was applied in this case, Divisional Court paragraph 82. And it may just be here worth turning briefly to paragraph 85, because the Court will see margin of appreciation above paragraph 85. This is relevant to the discussion this morning. Margin of appreciation above paragraph 85. And then intensity of review, paragraph 90. Lord Justice Leggett noting at 85, the margin of appreciation derives from ECHR, and then paragraph 87, full area of judgment in social and economic policy.
So where are you quoting from?
That's paragraph 87.
Yes, which bit of it?
First line.
Yep.
And then a further account that I don't think I need to take the Court through as to the reasons for that. Full area of judgment in those areas. But then, my lady and my lords, intensity of review, paragraph 90. Assessing proportionality intensity, this is middle of paragraph 90 at the bottom of page 430 in the bundle. In assessing proportionality and intensity with which a court will scrutinise a policy justification for a difference in treatment and on the circumstances, three factors in particular. Firstly, paragraph 91, the nature of the ground on which difference in treatment is based is significant. And my lords, and my lady, you have my submission there essentially already on the status relied upon here. Secondly, relevant consideration whether the measure resulting in differential treatment has been approved by Parliament, paragraph 92. And I would just draw the Court's attention to the very last sentence of paragraph 92, noting though that there are circumstances where there will be decisions of government working out details deliberately left by Parliament to be worked out in regulations, rather than decisions of Parliament in passing primary legislation. And then thirdly,
so is subsidiary legislation, which has not had, as Mr. Squire said, any positive analysis by Parliament to be equated with primary legislation. Is that what?
I don't take it as that. I take it though that one can't say that the rules that were enacted here are, if you like, out with any legislative control or oversight, because Parliament has, through the Prisons Act, empowered the Secretary of State to make rules for the good governance of prisons. So there is that. I accept it's not direct, but there is that process of legislative oversight inherent in the process. And then thirdly, the values and interests relevant were actually considered when the policy choice was made, and I'll come back to that in the ministerial submission. My respectful submission is that the...
So I suppose just read the next line as well.
Of course.
Thus,
of course, it's clear that where a public authority has addressed the particular issue before the court, has taken account of the relevant human rights consideration, make its decision, the court will be slower to upset the balance which was struck. And then conversely, as I say, we're to address that on the facts in due course. My lady and my lords, in light of that, my submission is that the Divisional Court was right to focus, as it did, paragraph 98 and paragraph 110, firstly on the status relied upon, and then secondly on the subject matter. The status here, perhaps best articulated by the Divisional Court at paragraph 92, where it held neither a classification of a sensitive or suspect kind, which requires particularly convincing or weighty.
You're rather rushing, I'm afraid. We've got to
Sorry.
find the passages. Just give us a little time.
Sorry.
Thank you.
I'm concerned about the time, but I will. It doesn't help anyone if I go too quickly. Paragraph 92.
Yes, thank you. Yes.
Not a status regarded as an essential aspect of an individual's personality. And then that's important when we come to the issue of justification. We do not consider this status lies towards the centre of Lord Walker's concentric circles that I just took the court to. Of course, important, it's more peripheral. And as to the nature of the status, the status here is, of course, one where there is a deportation order, and, of course, where the individual is appeal rights exhausted, but just taking the deportation order status. I give the court a cross-reference to Mr. Justice Blake and Brooke, Authorities tab 6, paragraph 15.
Just on paragraph 92, the Divisional Court seemed to say in terms that it doesn't require particularly convincing or weighty reasons. So they've distinguished themselves, their approach from the cases we were looking at this morning.
And in a sense, because we're, through no one's fault, we're running through Article 14 in reverse order. In some senses, we're dealing with justification first. But of course, before the Divisional Court, we dealt initially with, and therefore had that debate there about, well, what's the status? And my submission was, even if you're into other status here, it will have a significant impact when we get to the point of justification, which is the same point being made, I think, here, paragraph 92. So, my Lord, I think, given some of the discussion this morning, could I go, please, to tab 6 and the decision in Brooke? This is on the question of status, in particular deportation. Point made by Mr. Brooke, paragraph 15. And it begins at the second sentence. Removal or deportation is administrative action to which some foreign nationals are subject because of a combination of their immigration status and their offending. And that is a point I rely upon because obviously when we're into questions of offending and considered against Lord Walker's image of the concentric circles, that is obviously into the territory of free choice and therefore towards the outer limit of that. And just, my Lord, I think it was Lord Nugee raised a question about nationality and immigration status. Paragraph 20 may assist there on the relationship between foreign nationals and removability. Including the last two sentences, really no indication to racial distinction made by using the criteria of removability, criteria identified by the statute. Not even citizenship itself, which is the entire basis for the distinction. But as I say, the key point from my submission is that, assuming for present purposes, of course, deportation status, a deportation order amounts to status, it's on the basis, as Mr. Justice Blake identified at paragraph 15, of a combination of immigration status and offending. And
So nationality doesn't come into it?
Exactly. And so nationality doesn't come into it. And my Lord would have seen the ECHR's approach in bar, which was to say we have to identify status first, and once we're into legal status, we go down that route. If we'd gone nationality, we would have gone the other route. Well, this particular legal status has aspects of nationality underlying it, and therefore that affects the assessment. So that's on. This is all on margin of judgment.
And what do you submit, Mr. Watson, is the rationale behind that stark bar type choice?
I think because in my submission, it's the point at which one has to. It goes directly to the justification, because you're looking at what's the basis for the distinction here. So if the distinction is deportation order, i.e. immigration status and offending, then what you need to justify that is going to necessarily be different from if it's nationality. And one has to look carefully and precisely at what that distinction is. Firstly, to see if it's status at all, and then to ask the question, what impact does that have?
Because right, it's the stepping off point when you come to the analysis. You've got to come to a fixed point.
That's right, man.
On status. You either have a status or you don't.
And within that, there are different types of status that you have or you don't on the concentric circles. Otherwise, the decision in bar might well have looked rather different. Because it could well have been said in bar, well, it's specifically, it's not nationality, but there's plainly a nationality background to this. And we're going to rely upon that when we look at justification and our approach to justification. But they decide first what the status is. Is it nationality or other status? And having decided it's other status, they say these are the consequences that flow from that. I accept that in other Article 14 contexts, for example, justification generally, there is a broader, less hard-edged approach, but on status and its relationship to justification, it does appear that there is a bright line, to use that phrase from a different context, a bright line that's drawn.
And again, just pressing a bit as to logically, why does that approach? Why does it commend itself to the court in bar? Because it's a cleaner analysis, or what?
But I think because it is a cleaner analysis, but also because the question is, what's the heart of the issue is justification. And therefore the question is, what are you justifying? And in particular, what's the differential that's been identified? What is the thing that you're relying upon?
Compared with?
Well, when you're, if you like, I suppose, well, with your comparator, because you're asking the question, what's the difference? What's the basis of a distinction? What's the basis of a distinction? Is it nationality or something like that? Or is it something more like other status?
What you're saying is that in order to decide what the delta is, the differential.
Yes,
You've got to have a fixed point in order to decide who the comparators are.
yes. And then that has consequences. I accept that I'm reading into bar a rationale, but bar itself is clear that that is the proper approach to be taken.
And you say bar governs this issue.
My lord, yes. I don't know of any other circumstance where there's been a more fluid approach, and it had to grapple precisely with this issue. Legal status, is it immigration status or is it nationality? So if that is other status, then subject matter the issue here.
When you say subject matter, what do you mean by that?
The subject matter of the measure.
Yes.
The issue here is properly identified as prisoner allocation, and specifically the use of the valuable but limited resource of open prisons, and whether priority should be given to those who are going to be deported on tariff expiry rather than released into the community. In my submission, it is precisely the sort of question about balancing of resources where a substantial margin of appreciation applies. It is about resourcing.
Can you slow down a little bit? Thank you.
Sorry.
It is precisely the issue.
Precisely the question about the balancing of resources where a substantial margin of appreciation applies. So the factors relevant to width here. First, we are dealing with the allocation of finite resources, and the evidence as to the pressures on the open estate is in Dr. Bennett's statement, paragraphs 18 to 21. Particularly paragraph 19, which I'll come back to for ground 3, the evidence that at current capacity, the open estate cannot accommodate all individuals who've been approved for transfer into it. And paragraph 21 providing the details of the data as to availability, but explaining that there has to be a certain margin of beds kept free by the Population Management Service to ensure prisoners can be transferred, there being allocation restrictions. He identifies sexual offenders and arsonists, two particular categories. In paragraph 22, and finally, the number of prisoners eligible for transfer generally far exceeds the open estate's capacity. Secondly, my lady, my lords, the democratic legitimacy, a point I've already made, is conferred by Parliament in section 47 of the Prison Act 1952, which gives the Secretary of State power to make rules for the regulation and management of prisons.
Paragraph, section?
It's not in the authorities. It's section 47, sorry.
The Prison Act 1952.
It's in the Divisional Court's decision, paragraph 7. Thirdly, on consideration as to the implications of the measure, could I ask the court please to turn to the supplementary bundle. Firstly, paragraph 29 of Dr. Bennett's statement.
Okay.
page 13. Just invite the court, if I may, to read paragraph 29, page 13. This is a reference to the ministerial submission, the 6th of August. And then please, the ministerial submission itself, page 144, line tab 2. Paragraphs 8, 9, 10. And then paragraph 12, the full equality impact assessment, noting the differential impact.
No, let's just read 10, shall we?
Sorry.
So there was an EIA.
There was. I'll look over the page. 12B, C, D, and then paragraph 13.
There was an EIA, but in fact, on this document alone, there was no consideration to a lesser alternative. It was the rule or no rule.
I was just going to come to that.
Very well.
My lady. That's exactly right. I can't say that they explored every hill and every valley.
They didn't go near them.
Well, I think that's unfair. I will respectfully submit that's unfair, given the terms, in particular of paragraph 9 and 10, because there it is clear that looking at the broader landscape, they've asked the question, they say explored fully with the Home Office, whether this should apply at an earlier age, i.e. just at the point of a deportation order. So that would cut out all of those who are subject to a deportation order, not just those who are deportation order and ARE. The decision was that that couldn't be recommended. And that, in my respectful submission, I'm going to come to it, get to ground 2, was part of the consideration that led to the identification of a very specific category, deportation plus ARE. And having narrowed the category down to that specific section, the Secretary of State was entitled, or at least it wasn't unlawful in Article 14 terms, to take a class approach to that particular category. And I say paragraph 10 is relevant too, because at the time that Rule 7.1a was introduced, there was also a new policy tightening the criteria for moves to open. This is paragraph 10, release on temporary license for any prisoner who is liable to deportation, which essentially brought in that exceptional category or test that my learned friend would have here to apply here, would seek to apply here. So there was careful consideration as to whether that should apply to this category as well, because that's inherent in paragraphs 9 and 10.
Just show us which bits you particularly rely on for that.
This is paragraph 10.
Indeed, but which?
The rules will
Paragraph.
operate alongside the new policy described above, significantly tightens the criteria for moves to open or release on temporary licence for any prisoner who is liable to deportation. And then the last line, last sentence, we expect many more prisoners eligible for deportation to have exhausted appeal rights in the UK before they reach the point when they might otherwise have been considered for ROTL or for open conditions.
Does the combination of deportation and ARE, since it was a Venn diagram, heighten the risk, therefore, of potential for absconding? Is that the point, or what?
Well, the point is here that there's been an identification of a very specific category. Deportation and appeal rights exhausted. And it was legitimate for the Secretary of State to take a class approach to that category. That's the divisional.
And what is it about that class that marks the class out?
They are the features identified by the lower court. I'm going to come to them, but in summary, they are that these are prisoners who are, in the ordinary course of the operations of the policy, not going to require the resettlement opportunities afforded by open prisons, because they are under a different policy path, if you like, because it's anticipated that rather than having a period of resettlement in the United Kingdom, instead they'll be deported.
That's Bennett, paragraph 18 to 21, hopefully, as you've shown us. I don't.
Well, 18 to 21, sorry, is on classification.
Sorry.
I think it's going to be
30. 30. It does deal with.
Yes, and I'm going to, obviously I'm going to have to deal with it.
Sorry, you can come to it, sorry.
I think it's probably under, well, paragraph 28 sets out the rationale for the, so he's explaining the submission. And at C, prisoners expected to be deported do not require opportunities for resettlement in the UK, which are an inherent part of open conditions. In addition, necessarily carry a degree of risk, etc.
But as my lady has said, having come the foothills of the analysis didn't go that further step to say we could have a carve out.
No, my lord, but it's inherent in paragraphs. I accept that there's not a specific consideration given to, well, should we, in the cases of ARA prisoners who are subject to a deportation order, should we be considering their cases separately? But that was clearly decided to be inappropriate, reading paragraphs 9 and 10, because that's in a context where it has been decided, paragraph 10, that there should be that sort of approach, generally, for those who are liable to deportation. That's the first sentence of paragraph 10. And they've considered whether, at paragraph 9, whether the exclusion should apply to all those who are liable to deportation, and having explored fully with the Home Office, decision has been taken no. And it is, in my submission, a narrow class that we're dealing with, and a narrow class that is inherently unlikely to present any kind of exceptional features that would justify the decision to put them into open conditions in circumstances where the plan is to deport them. And that is a critical feature of the landscape that, in my submission, the appellant's case rather underplays. And I'll come back to that. We'll get to the facts.
Is your submission that having come to decide on a class, there's a limit to how much slicing and dicing
Yes, Mark.
the government should necessarily be required to do? There will always be exceptions.
That's right. And of course, the narrower you define the class, the less that's required by way of justification for treating that class as a class. The key features being in an ARA case, that individual doesn't have any long-term prospects of remaining in the United Kingdom, because they're subject to a deportation order with no further right of appeal against that order. They are only going one way.
If one looks at paragraph 28, and bearing in mind what Mr. Squire said when he was addressing the court this morning, that the policy of open conditions is the opportunity to reduce risk for the prisoner. Where is that addressed in paragraph 28?
My lady, the premise I would dispute, if I may. I'm going to come to it, but I can
Then
do
don't
it.
let me take you out of turn, but it is, I speak for myself, it is noticeable that nowhere in this reasoning is there a reference to such a consideration of reduction of risk.
My lady,
of the
could I just
prisoner.
ask your ladyship to turn to page 300
Yes, of course.
within the same bundle? Because the submission that was being put was that essentially it's testing that's the primary purpose of open conditions. I'd like the court to look at paragraph 2.20 and 2.21, page 300.
Yeah.
So this is within the Immigration Repatriation Removal Services Prison Instruction, PSI 52 2011. And 2.21, open prisons have a special function in assessing and preparing prisoners for release, providing an environment in which prisoners can assume more responsibility and benefit from opportunities to make decisions for themselves before returning to the outside community. A number of prisoners able to be placed in the community, completing a variety of work and training placements, again designed with the sole focus of improving a prisoner's chance of successful resettlement to the United Kingdom.
So is that what you're saying the purpose is?
So yes, my lady, and that indeed is that is what's relied on in the HDC, the Home Detention Curfew line of cases that the Divisional Court considered assisted them. It isn't testing, but rather, as it says there, I'm not saying testing isn't a part of it, plainly it is, for the prisoner in front of the Parole Board, but equally its ultimate aim is improving a prisoner's chance of successful resettlement in the United Kingdom. And that is then reflected in 28C of Dr. Bennett's statement that we were looking at. So to return, if I may, to the factors relevant to width, my fourth point is that this is not a measure which impinges upon a right to liberty. It concerns prisoner allocation in a context where the policy landscape is one where it's anticipated, the working assumption is that the appellant and those in his category will be removed from the United Kingdom at the point of their tariff expiry. policy terms, in this case, liberty will not be achieved through the passage through open conditions. Liberty, in this context, is through deportation, removal, under TERS. My lady and my lords, that point that this is not about liberty, but rather prisoner allocation, is in my submission made good by the nature of the discussion today and where we get to on grounds 2 and 3. The submissions are all about assessments of resourcing. The submissions are being put on the basis that you can look, for example, at closed prisons and see how overcrowded they are, and then ask a question of the Secretary of State as to, well, why is it that you're not prioritising prisoners to be moved into open? This is not the court grappling with questions of arbitrary detention or the legality of detention. And it's for those reasons, I submit, that in the HDC cases, the home detention curfew cases, the courts expressly rejected reliance on Rangelov, see Francis, Court of Appeal, paragraph 40, it's Authorities tab 8.
Right, we have to get these references down. Francis,
Authorities tab 8, paragraph 40, and A, by Mr. Justice Blake in Brooke, tab 6, paragraph 17. And could I therefore turn, please, to the cases of Clift, Rangelov, and A, because my submission is that there's no proper analogy to be drawn with the issues here as those that were being considered there, and specifically, no basis on which to curtail the margin of judgment on the basis of those authorities, i.e. to say those authorities demonstrate...
Can you give us that proposition again?
Sorry.
Slowly. Thank you very much.
No basis to curtail the margin of judgment which applies here by reference to those authorities.
Mr. Watson, my apologies for taking you back, but I was so busily writing down what you were saying that I didn't have a chance to ask the question. But can I just go back to what you were saying, that liberty here is not achieved through open conditions, it's through deportation under TERS. But the reality of TERS is that there is an exclusion of terrorist offences. And one of the factors of which account has to be taken is the significant risk that prisoners pose. And relevant to that, on the submissions of Mr. Squires, is the opportunity to be in open conditions. So the link is there.
My lady, with my submission, it isn't there. I'm going to deal with it, but I don't mind addressing it now.
If you're going to deal with it, take it in your own time.
Okay. But there is an answer to that, because and the short answer is it's a different process that applies. There is a particular risk assessment undertaken by the Parole Board which in its context will ordinarily consider time in open conditions. Where we are under TERS, as Dr. Bennett explains, while there is the carve-out of those who've been convicted of a terrorist offence, a period in open conditions is not necessary to be satisfied that removal shouldn't be refused under the fourth criteria, and that is Bennett 57B on page 23.
No, I accept that as a proposition, but a period in open would assist a prisoner on the issue of reduction of risk, assuming all went well.
As the Divisional Court expressly found.
Well, my lords and my lady, on the TERS point, the issue is different before the Secretary of State under TERS, because, of course, within the context of TERS, there's no opportunity for any period in open conditions. So it's a premise of the assessment made under TERS, even in a terrorist case, put it bluntly, that there has been no period in open conditions. So it can't be said against a prisoner, well, you would have been been capable of removal, but you haven't had a period in open conditions, because the whole system has been predicated
It's already discounted.
in a context where there is no possible transfer to open conditions, so it couldn't be held against the prisoner. And if one looks carefully, it isn't a risk assessment done in the same way under TERS as it is by the Parole Board. And the evidence is there was a deliberate decision taken not to simply replicate, if you like, the Parole Board risk assessment process, because that would undermine one of the significant aims of TERS, which was to remove prisoners more quickly and efficiently without asking questions as to risk, etc., that go through the Parole Board.
It's a much more terse test.
I should say congratulations. Yes, that's right. It is. Paragraph 57, my lord, is the reference, 56, sorry,
Of
Bennett.
Bennett.
It's not a risk-based decision. This is ordinarily under TERS. Different considerations apply in terrorism-related cases. Decided, though, this is 56, making a full risk assessment would simply replicate the existing parole process, thereby negating the underlying purpose of TERS. And then over the page, on page 23, in the middle of the page, you'll see necessarily the case point towards the end of paragraph 57b. A period in open conditions is not necessary to be satisfied. The removal under TERS should not be refused under the fourth criteria. Necessarily the case because TERS operates in a context where 7.1a precludes such business from open conditions.
Where does it say it's not a risk-based assessment?
That's paragraph 56. Not a risk-based decision.
Not a risk-based decision.
Previously decided to make a full risk assessment, simply replicate the existing parole processes. And then in this particular claimant's case, 84, this will be the first case. In fact, we know from the second statement this is the second case.
Sorry, page?
Page 28,
Paragraph.
84.
Paragraph
84.
84, thank you.
Considered against up-to-date information from the prison and other partner agencies as to whether he poses an ongoing terrorist threat to the UK or abroad. And that it cannot, in my submission, be regarded as equivalent to a parole board assessment that is relying on a period of testing in open conditions. Assuming the review has reached that the evidence doesn't suggest he poses such a threat, the anticipated outcome of the process would be that the claim will be removed pursuant to TERS following his tariff expiry. And just for completeness, at tab 5, we have the updating statement, page 372, paragraph 15. Refers to one case having been considered under terrorism or terrorism-related offence criteria and removal under TERS was approved. So we can certainly say in that case, no objection taken, as in principle it couldn't be in my submission, that hadn't had a period in open conditions. That individual obviously able to satisfy that he no longer posed an ongoing terrorist threat to the United Kingdom. That being the TERS criteria.
Is the consideration both in relation to domestic threat, if X was to return, but also the threat that might pose to the receiving country?
My reading of threat to the UK or abroad is that it's both.
Both, yeah.
Well, and abroad. Yeah.
And is the rationale for this what you say is a narrower, tighter test because of the nature of terrorism and in the sense that the difficulty of assessing the risk with ordinary risk-based tools? Or what?
I would anticipate that it's more the necessary public concern that would arise, and also the broader public interest concerns that arise.
It's a sharper test, sharper tool.
Yes, my lord, I think that's fair. Yes, and it arises in a terrorism case, my submission, for understandable reasons, given the potential risk that such an individual might pose. But it couldn't properly be said. It would be an inherent flaw in the TERS scheme if one were to say of terrorist offenders, you can't have access to open under Rule 7.1a. We're nevertheless going to run a risk assessment along the lines of the Parole Board. And like the Parole Board, we would ordinarily expect to have a bit of period in open conditions to see how you managed. And that hasn't been established. That's not the way it works. It is a different process that applies under TERS. And of course, I will come back to it at some point today.
Sorry.
I'm going to try and speed up, but some point this evening, some point today, because it is a critical part of my learner friend submissions that he falls within this terrorist exception. But my submission is that that's also highly relevant to the status question, because he is not simply saying this is a concern for all ARE deportation order prisoners, but specifically the real issue, the gravamen that I struggle with in my particular case, is that I'm a terrorist offender. So, and there he's in a category of, we now know 2, but he was in a category of 1. And my lords and my lady, there is a sense, no criticism of my learned friend for this, but there's a sense in which the submissions range from almost a challenge to the particular circumstances of this individual's case, but then against a broader background of a challenge to Rule 7. And my submission is that we have to be precise about what is in fact being challenged here. It is a challenge to 7.1a, and therefore there's a limited extent to which one particular prisoner, particularly if that individual is in a category of 1 or 2, can say, look at my specific circumstances. They demonstrate that this isn't justified. We have to look at it. My submission is the court has to look at it on a class basis.
As I put to Mr. Squires
As you did.
early on. Yeah.
That's right. So, I was going to turn, if I may, to Clift, Rangelov, and A. And if I could start with Clift, this is Authorities 17. And paragraph 37 is the key paragraph paragraph 73 is the key paragraph. And my first point is that the proper way of reading what is becoming the key sentence, which is the final sentence, while in principle a similar wide margin of appreciation, and to be clear, that similar wide margin is the manifestly without reasonable foundation margin. So the ECHR is saying in terms, this maybe a point Lord Justice Hickinbottom would want to put, MWRF is being said to be similar in its width to the test that applies in questions of prisoner and penal policy, and then nonetheless exercise close scrutiny where there is a complaint, domestic motive, result of detention, etc. The nonetheless in my submission can't be read, shouldn't properly be read, as identifying 2 separate categories and you're in that one or you're in the other. And consistent with that, in my submission, is the decision and the analysis of Lord Justice Leggett in SC under the headings margin and then scrutiny. But the bigger submission, or the bigger point I make, my lady and my lords, is that the close scrutiny is where there is a complaint that domestic measures have resulted in detention which was arbitrary or unlawful. My
Can you say
submission
it again?
where there is a complaint that domestic measures have resulted in detention which was arbitrary or unlawful. And my submission is we are not in that territory. Because the issue in Clift was whether Clift should be released. He'd remained in prison following Parole Board's recommendation of release, which the Secretary of State had declined to approve. That's paragraph 3 of the ECHR judgment. And one, in my submission, can readily see why in that context, arbitrary, unlawful, detention potentially in view, that close scrutiny would be required. My submission is that that isn't the factual context here. In my submission, we are therefore here within the first clause, i.e. similar wide margin of appreciation in questions of prisoner and penal policy. Rangelov, tab 18, next tab. Paragraph 87, which we've looked at already, essentially seem the same. And again, though, close scrutiny is where domestic measures have resulted in detention which was arbitrary or unlawful. And of course, this in the context of nationality. And 93, when the court turns to the implications of the domestic measures, he was essentially, Rangelov, being precluded, this is paragraph 93, from successfully completing suitable therapy that would be an important precondition that he would no longer be dangerous and therefore could be released. Paragraph 95 briefly for the nationality, but then paragraph 99 for the conclusion. Last sentence, he was denied a chance to fulfill essential preconditions for the domestic courts to conclude that the execution of the preventive detention order against him could be suspended and probation granted. Again, my lady and my lords, that is about release. And as I said, in Francis, the Court of Appeal didn't consider, paragraph 40, tab 8, that Rangelov, which was brought to their attention, assisted. Paragraph 40, tab 8, Diana Francis, or Justice Pill, second sentence, or rather, start at the beginning, a clear justification and substance for the distinction between
Sorry,
foreign
paragraph.
Paragraph 40. Reasoning as to delay is persuasive. In any event, which we can ignore for the moment, there is a clear justification and substance for the distinction between foreign and national prisoners. And then this, a scheme designed to promote resettlement into the UK community cannot be expected to apply on the same terms to those subject to notice of intention to make a deportation order. That analysis in my submission applies here, and then the case is very different from the denial of medical therapy in Rangelov. And in my submission, those points are a fortiori when we turn to A and others, the House of Lords, which of course directly concern detention of non-nationals on the basis their presence was a risk to national security but couldn't be deported due to fears for safety. Not an issue of prisoner and penal policy. Indeed, the premise of the case was that they weren't prisoners or being punished. drawn to the attention of the court, President Sir Anthony May and Mr Justice Blake and Brooke, tab 6.
Are you going to take us to the Belmarsh case or show us which paragraphs or not?
My Lord, I wasn't planning to, because the facts of the case, given that they concern detention of non-nationals, and the questions to the legality of that detention, are in my submission so very clearly far apart from that which we're dealing with here, and plainly didn't concern penal and prisoner policy, as I said, no punishment at all.
So you draw a clear distinction between
Each of those
prisoner and penal policy on the one hand and detention,
if you like, the liberty cases.
liberty
If I
on
can
the other
use that
hand.
phrase, the liberty cases of Rangelov, Clift, and A. And my submission is that close scrutiny that the European Court holds as necessary in those cases is directed at the fact that the concern is arbitrary detention, as it was on the facts of Clift and Rangelov. And we're not in that territory, is my submission.
What happened in Rangelov, if I've understood it correctly, was that because he was Bulgarian, he was unable to access a particular program of therapy, which was a precondition to being considered for release on the grounds that he was no longer a risk.
Yes, fine.
Mr. Squires says that's very similar on the facts, where because Mr. Akbar is not eligible for transfer to open conditions, he cannot be assessed for his ability to demonstrate the effectiveness of the management of risk through the programs he's engaged in closed conditions in a way that other people can, and therefore it isn't that he can never be released, it's not a precondition in that sense, but it makes it more difficult for him to be released. And is that really the distinction?
Well, my Lord,
Or do you say it's no more difficult for him to demonstrate his ceasing to be a risk than for people who do move to open conditions?
he's in a completely different category because he is subject to TERS, and that's the relevant distinguishing feature. Because under TERS, he does not have to demonstrate to the Parole Board that he's reduced his risk, and that he's done that ideally, not necessarily, but ideally by a period of open conditions. TERS, and of course, as I say, is in a category of 1, generally, perhaps more accurately, the Rule 7.1a prohibition is operating in a context where people are not going to have to show any period in open conditions in order to secure their liberty. Because under TERS, the plan is, and in fact they are, removed. So
But
it's not
for most people, there's a presumption.
For the vast majority, I think it's only 22 out of 500 is the evidence that we had.
But there are people like Mr. Akbar for whom there's no presumption. In his case, because of the terrorism offences, but there are other categories.
Yes.
But in his case,
Well, my Lord, that's where we're back to the discussion I was having
Yes.
with Lady Justice Nicola Davies, because it would be different, I accept, if what was required was still in a terrorism case to demonstrate a parole board type risk reduction,
yes,
because then you would have created the impossibility, a bit like Rangelov,
yes.
not on the grounds of nationality, but on the grounds of other status, deportation, ARE, etc.
Well, that's why I asked Mr. Squires. His case is not that Mr. Akbar will never be released, that he's stuck in some Kafkaesque limbo. It's just that it's more difficult for him, he says. And it's your submission that it's not difficult for him.
Precisely. That it would be difficult if you weren't within the TERS regime, but the 7.1a sits within the TERS regime.
And how do you, in the TERS regime, as a terrorist, demonstrate you're no longer a threat to the UK or other countries, which is what you need to demonstrate?
Well, that is, we have there the evidence of Dr. Bennett, and what you don't have to do is to show through a period in open conditions that you have reduced the risk to the local population or the risk of reoffending, or that you can resettle in the United Kingdom, which is the purpose of the open conditions. it is in my
So,
section.
you demonstrate it by showing
as he says,
progression.
through all the other, as we know, there are, and as in the evidence, there are a series of other measures. In fact, the primary measures are not, in fact, periods in open conditions, but there are courses that are undertaken in closed conditions. There are reports that are provided of individuals' conduct in closed conditions. And on the appellant's own case, he is a model prisoner. There's no prison for that, but that's the way he would present himself. And he doesn't pose. There's been nothing that would flag him as of concern. And so on the operation of the policy under TERS, it's, in my submission, one can properly anticipate that he will meet the criteria. Of course, no one can prejudge that. It's an assessment that Dr. Bennett says that will be taken when it's made.
So are you saying it would be no advantage to him to access open conditions in terms of his release date? I mean,
in terms of his removal under TERS, if I may be precise, it can't improve his position under TERS because TERS operates in circumstances where there is no open conditions available to anyone. Well, that's the premise of it, that there isn't access to open conditions. There are, as the evidence demonstrates, other mechanisms to demonstrate change in prison and to be able, therefore, to satisfy the decision maker that you no longer pose the terrorist threat that you did when you committed the offence 17 years ago. And there's evidence, of course, of that working because there's been one prisoner who's passed through it, who's satisfied without any period in open conditions, no longer poses a terrorist threat, falls outside the exclusion under TERS and therefore can be deported and was deported.
My Lord's point, as I understand it, is, well, that aside, if a terrorist prisoner happened to go into open, it might help. It might, in practice, help. Your answer to that is, well, it's actually irrelevant because this is a completely separate process which has been bespoke for this category, and therefore rationally the decision that was made to create a special category can be justified.
That's right, my Lord. And there are also, of course, savings within the regime as well. And there are progression regimes. It's not, of course, we're focusing here on open conditions, and understandably, but they sit within a broader context. And so the lack of access to open conditions isn't the same as saying that prisoner can show no progress, because they're obviously, the majority of progress is demonstrated in closed conditions, as Dr. Bennett explains. So there's a proper basis for a decision maker to look at the terrorist threat and say, having spoken, I think, says to police and other agencies, satisfied you no longer pose a terrorist threat. That can be taken without a period in open conditions. Indeed, it's predicated on there being no open conditions.
Maybe that I'm being too simplistic, but it seems to me that means your case is really a challenge to the factual basis on which the appeal is brought, because the way it was opened to us was that Mr. Akbar needs access to open conditions to demonstrate his reduction in risk. That's a benefit which is being denied to him, and there's no sufficient reason put forward to deny it to him. And your answer is not, yes, there is a sufficient reason to deny it to him, but actually he's not losing anything of value at all, because he doesn't need open conditions, and it wouldn't help him to have open conditions given the exercise under TERS.
Under
Is
TERS,
that right?
That's right, my Lord, but I do have to accept in the Divisional Court, of course.
It wasn't. I didn't obviously see that in the Divisional Court, saying the whole thing's misconceived. It wouldn't help.
No,
at all.
for the reason I'm about to give, if I may, which is that there is, of course, the potential that under TERS, the decision is taken not to remove him, and therefore he falls back on the Parole Board processes. He's been offered progression regimes, they haven't been accepted. And in that context, a period in open conditions would be relevant to the Parole Board's assessment, and I can't say that it wouldn't be, because it would be. It's not the only mechanism of securing access, but I can't say in principle that it's irrelevant. But the premise of the TERS regime is that you don't have access to open conditions. So the absence of access to open conditions can't put
Disadvantage you.
can't disadvantage you, because it's premised on there being no such. And I know there's only one individual, but there isn't evidence to suggest that people are caught in a cycle, that terrorists are caught in a cycle of being unable to satisfy the Secretary of State of a reduction in terrorist threat because they needed a period in open conditions which is denied to them.
But is there a possibility of a cycle? Because we're very much at the early stages of this, aren't we? Applying the TERS regime, you say open is irrelevant. And so it is there a terrorist risk? Say he fails the TERS because he hasn't embarked on the progression regime for whatever reason. So he fails TERS, then they have to consider Section 28. As you have accepted, for Section 28, open conditions are relevant because there is the risk assessment. So one can see how a circle could start.
Yes, my lady, I accept that. But when we're dealing with a challenge under Article 14 grounds to the rule 7.1a, my submission is that one has to be careful about saying in a particular case, that individual has the potential, it hasn't happened, that individual has the potential to be caught in a trap or to be disadvantaged in circumstances where, firstly, that hasn't happened to him yet, it hasn't happened in the case that's already been considered, and he and the other person do not reflect the broad category or class of those affected by Rule 7.1a, who are deportation orders ARE prisoners. And so in terms of justification, the Secretary of State in my submission is entitled to take a class-based approach to the DOARE, deportation ordered, appeal rights exhausted category, narrow as that is. The claimant says, or the appellant says, in my particular circumstances there is this risk, but the policy answer is, in fact, TERS is intended to operate without reference to the Parole Board. Deliberately so. It was set up to do that, to avoid that, and instead to lead to removal immediately. Yes, there is a saving with respect to terrorist prisoners, but that doesn't require a Parole Board type risk assessment.
We didn't ask Mr. Squires, we might have replied as to what his position is. That is it just the terrorist exception that is unlawful, or whether it's all the those in the exceptional categories?
My understanding is that it's all, and my submission is it would have to be to get through status. Sorry, to get through status. Because otherwise your deportation order, appeal rights exhausted, and you've got to be a terrorist. And my submission is that wouldn't suffice for other status under Article 14. And if it did, given the relationship between status and justification, it would have a very, very significant impact on how the Secretary of State could properly approach that very narrow category of case.
Would it be big numbers then? Bigger numbers anyway?
No, my submission, sorry, is that you would be dealing with, thinking of Lord Walker's concentric circles, you would be so far outside the suspect categories of race, gender, etc., because your deportation order, appeal rights exhausted, and you're a terrorist, that in those circumstances, justification you would have a very, very substantial margin as to how you approach those particular cases, or that particular case or two.
Thank you.
So I hope I've dealt with the three, as I characterise them, liberty cases, and drawn the distinctions that I submit apply here. Returning to the authorities, I don't intend to go through Drexler or JCWI. I know that the court has the points on substantial margin, in fact, coming very close to, if not being exactly the same thing as manifestly without reasonable foundation.
Which of these many judgments do you say most accurately reflects the law?
Picking a child. If I had to choose one, I think my respectful submission is Drexler. It's probably the most helpful. And not least because paragraph 52 refers to the absence of material difference, which is really where my case ends in terms of the margin to be applied. So on justification, and I will take this,
Just define, if you would, absence of material difference in a sentence.
that applying the manifest foundation test on the one hand, or applying a traditional proportionality analysis in this context is essentially a distinction without a difference. So when the court then turns to having established, I hope, a substantial margin of judgment for the purposes of justification, on the Divisional Court's analysis, I'm going to take this very quickly just because of the time. My first submission is that the Divisional Court was correct to find assistance in the HDC cases, which have consistently upheld the fundamental and, in my submission, obvious distinction between those who are to be deported and those who are to remain in the United Kingdom. Paragraph 111 of the judgment, and C2, paragraph 114 of the judgment, where the court referred to the essential purpose of both HDC and open conditions being to manage the transition from custody. And I was going to go here, but I have done already, to page 300 of the supplementary bundle, which is PSI 52 2011, paragraph 2.21, and the court can contrast that, or compare and contrast that, with HDC, which is referred to in the same document at paragraph 2.43.
Sorry, you have to give me those references again.
So sorry, my lord. Page 300,
Yes,
paragraph 2.21,
yes.
and 2.43. One looking at open conditions, one looking at HDC. As, if you like, the factual basis for the submission that the HDC authorities do assist in this context, drawing as they do the fundamental distinction that
Between
those who are going to be resettled in the United Kingdom, having been released on licence or having served their sentence, and those who are going to be deported. With the one obviously requiring the resettlement opportunities open provides. And so HDC, 3 authorities, Brooke, tab 6 we've looked at. I would invite the court to look at paragraph 21. Referring to abundant justification for the HDC measure. Francis, tab 8, paragraphs 40 to 41. A scheme designed for reintegration into the community cannot be expected to operate in the same way for those liable to deportation. And Serrano, tab 7, paragraph 67. Holding there that even if nationality was the ground, there was clear justification for the difference in treatment in the HDC context. My lady and my lords, I was going to shortly run through the reasoning of the Divisional Court at paragraph 117, but I think given the time I'm not going to do that. But in my respectful submission, the 15 reasons given there in favour of justification are all matters that I rely upon, particularly given the identification at the outset that the TERS mandatory removal from prison provision has distinct advantages for most ISPs, rather than having to go before the Parole Board, and that's in the evidence of Dr. Bennett, because there's no requirement to show risk reduction.
No requirement to show
A risk reduction
a risk reduction.
in the ordinary TERS context. And I do rely on all of the matters there. I was aware on an appeal that the assumption that if you won the war the first time round, you don't have to win it again. I don't want to fall into that mistake. So I do urge the court, if I may respectfully, to read the analysis of paragraph 117, which draws on the evidence. And in my submission, would require very significant objections to either its reasoning or a premises to justify a different view being taken. On that basis, and I hope I've covered the ground one questions as they've arisen. I was anticipating to turn to ground two, if I may. Formulated in written submissions as giving up a power to act. Very shortly, my submission is that it is legally irrelevant to the analysis under Article 14 whether the differential approach was implemented when transfers to open prisons were first introduced or at any stage thereafter, i.e. saying at the outset this will only apply to these prisoners, or saying partway through, in fact, they're only going to apply to these prisoners. Legally irrelevant. Secondly, the impetus, and this is the Barbadian case, the impetus is also legally irrelevant and is to be contrasted with the policy background and aims of Rule 7.1a. Impetus, as the word suggests, can be anything that prompts reflection or a decision maker to look again at an issue. It doesn't inform, one can't read from that, gain any assistance from that impetus when then looking at the actual policy and the justifications that are given for it. Thirdly, it takes a particularly gloomy view of public administration to assume that any change has to be premised on a problem. It can always simply be improvement. A decision maker is entitled to look at a particular policy area and decide this could be made better. And four, the answer to the mischief, you haven't identified what was wrong. My submission is that the mischief is the flip side of the policy reasons that are given. So when it is said that at current capacity the open state cannot accommodate all individuals who've been approved for transfer to it, and that is part of the rationale for the approach that's being taken, my submission is that that's sufficient.
You have to have some sort of rationale, because
Yes.
Squire says, Lord Hope says you can't just stigmatise the bad guy. You know, it's
No, of course,
There
we
will be some-
just sort of blunder blindly through a field of policy. No, I accept that, but one doesn't have to look for a particular problem or mischief and say that's the problem, that's the mischief. Because, in a sense, any feature of the policy context, for example, open conditions are operationally full, that provides, in my respectful submission, a proper basis for saying that's the mischief. That's part of what we're seeking to address here. Because then you look at, well, who actually should be prioritised for that limited resource? And then in my submission, one is entitled to say, subject to the issues of justification, one's entitled to say, well, those who are subject to deportation, who have no extant right of appeal against that order, and who are therefore going to be removed, they should not have priority.
And it's not that they don't have priority, that they don't have it.
They don't have it, I'm sorry. Yes, that's right. That's right. And then, my lords, within this, within ground two, I think we have what has become the primary basis of my learned friend's arguments before this court. This was the backstop point before the lower court, was essentially replace this scheme with one that permits the Secretary of State to exercise a discretion in each of these cases to determine whether there is any exceptional reason why this particular prisoner should in fact have access to open conditions. It was, as I say, a backstop point. It was rejected by the lower court, paragraph 118. And the kernel of the reasons given there, I adopt for this appeal. That firstly, ARE prisoners are in a materially different position from others, such that it's generally justified to treat them differently when affording access to open. The material differences include primarily that the aim is to secure their removal from the UK rather than their release and resettlement within the UK. They apply as a matter of generality, and they are unlikely to be highly fact-sensitive differences between many such ARE prisoners, which impact significantly on that material difference. And my submission is that the more closely defined the category is, as a matter of principle, the easier it is to justify taking a class approach. And of course, my lords, there are, if you like, savings or mitigations, such as the potential, or rather the fact of a parallel parole board process, which is referred to by Dr. Bennett, paragraph 54A, page 20. And of course, the progression regimes. Alongside the fact that in any event, once you get before the parole board, open conditions are not the necessary or the a necessary precondition for release in any event. I think the court has already my submissions on the differential approach adopted under TERS as against the parole board, because I've dealt with those, I hope, in answer to questions that have been asked. Then, my lady and my lords, briefly, I think, on ground 3. My submission here is generally that the actual content of the submissions advanced under this head are precisely issues going to resourcing, running of the prison estate, and penal policy, where the Secretary of State enjoys properly a substantial area of judgment. They are not areas which this court, on, and I should emphasise, on limited evidence, can properly take a view, and they are matters that should be left to the judgment of those looking to operate these policies in practice in the prison's estate. And I know too that just to draw to the court's attention that the various features of the arguments put this morning under ground 3 were considered by the Divisional Court. The waiting time point, for example, is addressed at paragraph 117, Roman 13. But in my submission, they are very squarely out with the sorts of areas that this court should properly be closely reviewing, particularly in circumstances where the bald point is that the evidence demonstrates open prisons are operationally full, and that there are more persons who are allocated to open than can be held there. That's in the evidence of Dr. Bennett.
in a nutshell, you say, Mr. Watson, that Mr. Squires is asking us to look at it through the wrong prism. The prism is not the liberty prism; it's the penal prison running
Policy
prison
and
policy.
prisoner allocation. And prisoner allocation policy.
That's the
And
essential
competing
difference.
resources, that's right, my lord.
That's the essential difference. Between
Yes, and I do think that I do have to put forward and can put forward ever that's the issue, which is why I emphasise the fact that the open prisons are operationally full. Once you have that, and you have more prisoners who should be in there than can be in there, my submission is once you've created that, then the judgments that are made as to whom that should be, who should enjoy that allocation, are really matters for the Secretary of State. Unless you can show some irrational approach.
Indeed, all those with red hair
Yes,
can't go into open.
of course. Subject to rationality and the ordinary grounds. Yes. So, my lady, my lords, I don't know if there are any... I've tried to sweep everything up, but if there are other points I've missed, obviously, otherwise, I'm going to do my very best to deal with our grounds very shortly, if I may.
Indeed.
I didn't sense enthusiasm, but
Well, no.
permission.
We have to maintain poker faces in case we can't disguise our excitement.
I appreciate that.
But no, indeed. We've read everything, and so we understand.
Yes.
But we would very much welcome.
I'll try and do it briefly, and I can say immediately that because we've addressed status already, you essentially have my submissions there, so that will be very, very short indeed.
Indeed.
On ambit, this was the subject of a short note that I filed on Friday in an attempt to focus the issue, so I hope you saw that.
Indeed,
The
thank you.
essential distinction, and now that we've been around these authorities, I hope I can do this quickly. The essential submission I make is that the test established or articulated by Lord Bingham in Clift, paragraph 13, applies here when considering ambit. And this is not a case where a more than a tenuous connection test applies. And therefore, Clift, paragraph 13, where the circumstances are such that a personal interest close to the core of a convention right is infringed, is the test. Four increasingly short points to make in support of that. Firstly, and to address the criticism forcefully made in my learned friend's written submissions that there's no rational basis for taking a different approach to different substantive provisions of the Convention. I would invite the Court to look at M, Authorities tab 4, paragraph 60. Just ask the Court to turn to it briefly, where Lord Walker says in terms, paragraph 60.
Turn.
Tab 4.
Thank you.
Last two sentences of the paragraph. This is on the question of ambit. There is no simple bright line test as to what the test for ambit should be.
Paragraph.
Paragraph 60,
Thank you.
page 140. It does not, in my opinion, lead to the conclusion that even a tenuous link is sufficient. Then this, nor does it lead to the conclusion that precisely the same sort of approach is appropriate, whatever substantive article is in point. That is particularly important, I think, in considering the ambit of Article 8. So there is good authority for the proposition that the approach to the test may be different, and that Article 8 may have its own considerations that affect the approach to ambit there. I do, though, need to point out paragraph 61, the context of that Article 8 observation, paragraph 60, at the end of paragraph 61. In fact, Lord Walker goes on to argue that if you like, the approach to ambit has to be more carefully constrained in Article 8 cases because the substantive provision is wider and less well defined in its ambit.
Wait, what was the second paragraph?
Paragraph 61, just on the same page,
Yes, thank you.
very last sentence.
does that differ from the Bulgarian case, where it's suggested that it doesn't matter what article one's dealing with?
It does, my lord, but my submission is that there is a proper distinction to be drawn between the Article 8 so-called positive modality cases and Article 5. I accept that there may be other distinctions. I'm deliberately, as I only need to, confining myself to Article 5 as opposed to Article 8 because it's complicated enough as it is. Clift paragraph 13.
I didn't know what a positive modality was
No.
until quite recently.
Yes. And my submission is that it's not to be confused with a positive measure. And it's a deliberate distinction that I draw, and that is the jumping off point in my submission where I say that the lower court erred. But just to take that as a proposition that it doesn't have to be the same across all substantive provisions. Second, I think already made good is that House of Lords authority in Clift, paragraph 13, for the approach in an Article 5 case. And my submission is that there's nothing since then that has expressly overruled or overturned that. That approach in Clift, I would emphasise, is one that takes place in the context of a so-called positive measure. And I'm aware that this may sound tedious, but it is an important distinction in my submission. A positive measure in the Clift sense is when, as in Clift, the state decides to take a measure that is not required to do, for example, providing for early release of prisoners. Not required under Article 5, but it decides to take the measure. That is a positive measure. And Clift, Lord Bingham in Clift, holds that if you do that, then the application of that measure will have to be undertaken in a non-discriminatory Article 14 compliant way when you undertake that measure. That is Clift 13 and 17. In 17, the Convention doesn't require Member States to establish a scheme for early release. They could be required to serve every day of their sentence. That's not what the law of England and Wales provides. It must, though, instead it provides for a system of early release. And if you provide for that, end of paragraph 18, then the potential for an Article 14 discrimination case arises if the measure falls within the test at paragraph 13. Not necessarily to show substantive right violated, but personal interest close to the core is infringed. That test was then applied, and I say that just to make it clear that this isn't some idiosyncratic approach that I'm urging. It was applied in Serrano and Ryder. We don't need to go to, but Serrano tab 7. Paragraph 50. So sorry, I am going to have to go to Serrano for one point. So tab 7.
Yep.
Sorry, it's a trap we all fall into. Paragraph 50 in Serrano. Just to see the Clift, and then 53, the test in Clift. Personal interest close to the core of the right of such a right is infringed. And I do want to address the point made at paragraph 54 because it reflects a point made by my learned friend in the skeleton, where it is said, essentially, well, if you're right about ambit, and if you're right, therefore, that this measure falls outside the ambit, are you really saying that you could adopt an explicitly discriminatory policy, for example, making open conditions or HDC only available, as they say here, to white men? And my submission is that that's a forensically powerful point, but in my submission is that it's legally unprincipled and doesn't assist in resolving the question of ambit. And I say that because it's a point taken against me here. And the reason I contend it's unprincipled is that it has to be accepted that there are cases that are outside the ambit of Article 5. There are circumstances that don't fall within that category. Once it's accepted that there are cases that fall outside the category, then in those circumstances, there could be no Article 14 objection, however outrageous the discrimination sounded. But just because it sounds outrageous, my submission is doesn't bring it within the ambit. There's a careful and closer analysis required first to say, is it within the ambit? And it isn't useful within that context to posit a situation where you say, for example, here, well, are you really saying that Rule 7.1a would be acceptable under Article 14 grounds if it only applied to white people? My submission is that that doesn't control the earlier test of ambit. There might be all sorts of other flaws with it, but it doesn't help resolve ambit. Same test applied, so that's Serrano. Then Ryder applied the same test, and indeed my learned friend or the appellant in the court below also sought to apply under Article 5 the Clift test. That's in your core bundle, tab 23, page 240, paragraph 61 to 62. But the fourth and critical proposition is that a different approach has been adopted in a so-called positive modality case under Article 8, where the measure concerns the discharge of a positive obligation. And so Steinfeld tab 12 is where, in my submission, this distinction is drawn by Lady Justice Arden. And it's a detailed analysis, and I don't want to take time going through it, but the primary submission I make is that Lady Justice Arden's analysis that the more than tenuous connection applies, and that therefore that the Clift analysis does not apply, because it was being urged on her, in fact by Mr. Squires, that the Clift approach should apply under Article 8. That was rejected, but it was rejected on the basis that you were dealing in Steinfeld with a positive obligation. State's discharge of its positive obligation to show respect for family life. And in that context, didn't have to show an adverse effect. So paragraph 25 of Steinfeld, tab 12. There, Lady Justice Arden summarises her conclusions, paragraph 25. In that context, you don't need where you're promoting family life, so your positive modality is your positive measure, means by which or modality by which you give effect to your respect for family life. In that context, only a more than tenuous connection is required. And that is, I don't think I need to take the court through the detail, but that is the analysis and the conclusion from 25 onwards. Paragraph 47 to 48, you'll see the submission being put that the Clift approach, personal interest close to a core of a substantive right, is infringed, paragraph 48, taken from Clift. Also adopted there, says paragraph 49, in Countryside Alliance. And the submission being that that should also apply, and that was rejected on the basis, paragraph 61 through to 69. And in particular, 63 to 69, where this distinction is drawn most clearly. We'll ask the court just to turn to page 346. Paragraph 63, Article 8 contains both negative and positive obligations. In M, the Lords had to deal with both types. Lord Walker drew a distinction between positive and negative obligations in Article 8. Right, I might just ask the court just to read through to the bottom of 69.
Yes.
Turning then very briefly to Smith, because that Steinfeld, now Steinfeld or Steinfeld was not before the lower court, but Smith was. I'd ask the court to turn to paragraph 55 in Smith. This follows a similar discussion as to scope, ambit and core values, but paragraph 55 just for this conclusion. The legal position may therefore be summarised as follows in a case where, as here, infringement of Article 14 in conjunction with Article 8, so limiting to Article 8. It's capable of falling within Article 14 even though no infringement of 8, if the state has brought into existence a positive measure, which even though not required by Article 8 is a modality of the exercise of the rights guaranteed by Article 8. The state will be in breach of 14 if the measure is more than a tenuous connection. Not necessarily the measure has any adverse impact in a positive modality case, other than the fact the complainant is not entitled to the benefit of the positive measure in question. So my lords and my lady, closely read, Smith is only maintaining the same distinction. Where you're dealing with a discharge of a positive obligation on the state to ensure respect for family life, and you're dealing with a measure, which is the modality or means by which the state discharges that obligation, then you only need to establish a more than tenuous connection. Otherwise, my submission is that the Clift test applies. And my respectful submission is that the decision in Akbar, our case, paragraph 69 to 79, essentially conflated two concepts. The positive measure, i.e. the fact that the state had introduced a system of open prisons, with a positive modality, and said, because we're dealing with a positive measure...
We're going too fast on that. Can you just...
I'm so sorry.
Conflate the two things.
Two concepts. A positive measure, which here it is said is the establishment of an open prison estate. Open prisons.
Yes.
And a positive modality, i.e. in the context of a positive obligation under the Convention, adopting a measure which is the means by which the state discharges that obligation. Because my submission is that when you're in that positive modality context, then you are into no more than a tenuous connection. Outside that context, Article 5, then you are where we were with Clift, paragraph 13. And if the court wants a submission on the rationale, or why should the test be different? Why should you have a different test for Article 5? My submission is that when you're dealing with the discharge of a positive obligation under Article 8, you're dealing with a provision where the state has deliberately sought to discharge an obligation on it by introducing a means or modality that promotes that objective. So you're necessarily firstly dealing with something that is likely to be very close to the right protected, because you're deliberately stepping into the arena. But also the language of infringement, which is really what's lost in the test. No need to show infringement. The language of infringement is inapt where you're dealing with a positive measure to show respect for something. Because one couldn't say of a welfare benefits case or any other measure designed to promote family life that really had anything to do with a breach of an obligation. It's a positive measure you've deliberately decided to take as a state. And that's where the more than tenuous connection approach arises. So if that's correct, and that is the correct test on paragraph 13, my submission is that the...
Paragraph 13 of...
Oh, sorry, of Clift. Clift, paragraph 13. that we are not here dealing with circumstances where a personal interest close to the core of the right is infringed. And I can take this briefly because you'll have the submissions already. The core of the right is, of course, the protection against arbitrary or unjustified deprivation of liberty. And as to that, firstly, the appellant enjoys no right to liberty at this stage, lawfully detained pursuant to a sentence. Secondly, claim is not in fact directed towards the provision controlling his release or liberty, but rather his categorization. Thirdly, even in the context of his pre-tariff categorization, the appellant enjoys no right, so leaving aside TERS, the appellant enjoys no right to transfer to open conditions. Instead, and these are points that were all made by my learned friend earlier, he would be eligible for a pre-tariff SIFT by the Parole Board. Secondly, which might lead to a Parole Board assessment supportive of a transfer to open. But thirdly, that would remain at the discretion of the Secretary of State. This is all leaving aside TERS, but that's the thing he says he's lost, if you like. And my submission is that that is not infringing a core value. Sorry, infringing a value close to the core of the right to freedom from arbitrary detention. And finally, that's on the appellant's case. Finally, in fact, as we've discussed already, my submission is that under TERS he's due to be deported. And therefore this isn't really an issue of his potential enjoyment of liberty in the traditional sense. Because of course, in one sense, liberty follows him either way, following removal. And on that basis, my submission is that this case, properly analysed, fell outside the ambit of Article 5. You'll have seen a discussion before the Divisional Court of the case of Ryder in tab 9. Just invite the court to look at paragraph 42 in due course, which is where Lord Justice Davies considers, in analogous circumstances, I submit, whether the test properly was met there. The Clift paragraph 13 test.
Ryder paragraph 42. Is it? 42, thank you.
42.
Thank you.
Other status, as I said, I'll be very, very brief on this. My submission, well, to take it in stages. Accepting for present purposes that those who are subject to a deportation order have other status for the purposes of Article 14. So I'm not seeking to argue that it's the deportation order that's delineated. In fact, though, the critical differential here is not whether an individual has or does not have a deportation order. In fact, the critical differential is whether they are appeal rights exhausted. Now, the Divisional Court didn't consider that to be a particularly significant aspect of the case. Paragraph 89 played it down as a mere procedural incident. My submission is that it is a mere procedural incident, but for Article 14 purposes, it's the critical incident. Because it's only on the basis of that ARE feature that Rule 7.1a applies. And my submission is that that is a step beyond a mere deportation order status or an immigration status, and into an immigration status plus a particular procedural state, namely appeal rights exhausted. And further, these are points 4, 5 and 6 in my skeleton. Further and finally, properly analysed, the appellant's case really comes down to his position as a terrorist. because that is how he says he's going to lose out, because he says, in light of the exemption under TERS, in fact, I'm going to have to demonstrate a reduction in risk, and therefore the loss of open affects me. And so my submission is that properly analysed, his case on discrimination relies on three features: deportation order, ARE, and subject to the terrorist exemption under TERS. And if the second step doesn't take him outside of other status, my submission is that the third does. And in any event, and I'm sorry this is going to be the wrong way around, but in any event, if that's right, but it is within other status, that has profound implications in my submission for the approach to justification.
Say that again?
If it is right that the critical features of his case are deportation order plus appeal rights exhausted plus terrorist exemption under TERS, if it's those three features, but I'm wrong that that doesn't amount to other status and the court satisfied that that is in fact other status, my submission is that in line with Barr that we looked at earlier, that will have profound implications for justification, because you're then down to a very, very narrow category, far away in Walker's concentric circles from the heart or the centre, and therefore where you would have a very substantial margin of appreciation. My Lords, my Lady, that's what I intended to say on those additional reasons.
Thank you very much. Excellent. Mr. Squires.
But also, I'm also conscious of the time. I'm happy to start. I'm also happy to put something short in writing, if that's...
That'd be kind. I'm afraid I do have a meeting 4:30, so we have to rise then.
I mean, I wonder if I might ask an opportunity to put something in writing, which I can do briefly. I think we'll aim tomorrow. I'm just slightly concerned that I won't be able to...
Indeed. Make whatever progress you'd like now if you want to make some general submissions, but I think we'd be very happy to receive something in writing.
I wonder if I might make them all, in perhaps in fairness, my learned friend, to make them all in writing rather than give you some highlight points, unless there was something particularly you wanted to push me on at this stage. Maybe one point I think was suggested, well, that's something that I might wish to address, is this just about terrorism prisoners? That's the concern. And I think I can address the answer is, firstly, it's not. It's anyone who is not released under TERS, anyone not presumed suitable. For example, there are people I think who are subject to confiscation orders, is another category. They may well, the Secretary of State may think, well, I don't want to remove this person from the country at this stage. At tariff expiry, they will want to go in front of the Parole Board and say, look, I am not a risk, so you can release me. So as we said, it's about 5 to 10%, it looks like, the figures are, of which I think on that figure's none are terrorism. So it's anyone who is not going to be presumed suitable.
All those in the exceptional category.
Yes, they're all affected. Second point, if I could just address now, a suggestion that it will not make a difference to him under TERS. Well, we say that is directly inconsistent with what was found by the Divisional Court, which is it will have an impact on his prospect of release. And of course, if you're doing a risk analysis, whether it's under TERS or under the Parole Board, to see if someone is a terrorist threat, it will be positively irrational not to look at how they've done in open as one of the factors that you will consider. It improves your chances. That's the same with anyone in front of the Parole Board. It must be the same if that is a rational way of assessing someone's threat when the Secretary of State looks at the question of terrorist threat. But if I may, I mean, those were the 3 points that leapt up, but if I may put something briefly in, we'll aim to get something by tomorrow.
That would be very kind.
Mr. Squire, speaking for myself, Mr. Watson said in terms, Section 1A sits within the TERS regime. For myself, I'd be grateful if you could address that in written submissions.
Yes.
Thank you very much.
Good. Well, can I, on behalf of the court, thank all counsel and the scholars sitting behind them for all the work that's gone into this interesting case. We will, of course, reserve judgment. Our judgments will be handed down in the usual way. Prior to that, counsel will be receiving copies for any infelicities of a minor nature to be pointed out. It is not necessary for counsel to attend at the handing down, but can I say what a pleasure it has been having counsel present in court today, and it's very good to see you all back. Thank you very much indeed.
Court rise.
Sorry I took so long.
No. I was just trying to work out whether it was.